Legal experts say that because of the novel legal issues raised by the case that Manhattan prosecutors have brought against former President Donald Trump for allegedly falsifying business records to conceal hush money payments related to the 2016 campaign, the prosecution is risky but not impossible. White-collar defense attorneys and election law experts have expressed skepticism about the way Manhattan District Attorney Alvin Bragg has presented his accusations against Trump. However, other experts emphasize that Bragg has a case that might legitimately result in a guilty verdict and that his legal theories are sound, if untested. Former federal prosecutor and current criminal law and procedure professor Cheryl Bader said, "There are some risks and complications, but I also think there is a path to conviction." More information about Donald Trump's historic indictment on the surface, the 34 counts of business record falsification against Trump, seem like a fairly straightforward accusation. However, Bragg has filed the charges, which are misdemeanors on their own, as felonies. That will require his team to demonstrate that the records were altered with the purpose of covering up or advancing another crime, but Tuesday's court documents offered little insight into how Bragg plans to prove an underlying crime. There are minimal requirements for what an indictment must say, and prosecutors are not required to reveal their hand at this point in the proceedings. Critics assert that more information would have been beneficial to the public, given the significant stakes in the case, and how it appears to depend on a novel theory for charging with a felony. The defense lawyer who focuses on political and election law, Robert Cowner, said, "I'm not saying there isn't a hint of what the other crime is. However, you would think that you would be very specific, given the peculiar local statute that requires proof of the intent to commit another crime, in order to prove one crime." The former president and front-runner for the Republican nomination for the White House in 2024 is facing legal trouble, in addition to the Manhattan hush money prosecution. Trump might be charged with a crime in Georgia in the upcoming weeks or months, as a result of a special grand jury investigation into his attempts to sabotage the 2020 election. Trump is also in grave legal danger as a result of the two federal grand jury investigations being overseen by special counsel Jack Smith, one focusing on the alleged subversion of the 2020 election, and the other on the allegedly stolen White House documents that were taken to Mar-a-Lago. Ty Cobb, a defense lawyer who represented the Trump White House in special counsel Robert Mueller's Russia investigation, said, "I think the Bragg case is the water pistol needlessly preceding the missile-launching F-35 attack, piloted by Jack Smith with Merrick Garland as his wingman." A straightforward record-keeping case that was charged as a felony became more challenging. The first step in the prosecution's case is to establish the falsity of a number of Trump business records, including invoices, checks, and general ledger entries, experts told CNN. The checks cut to Michael Cohen were incorrectly recorded as being for legal fees, but the prosecution will have tangible proof that he was actually being paid back for bribing adult film star Stormy Daniels. As a misdemeanor, Bragg would only need to prove that the records were altered with the intention of defrauding, another relatively simple obstacle to clear. The trickiest part of the case will be persuading courts and, ultimately, a jury that Bragg's 34 counts are justified, according to Paul S. Ryan, an elections law expert and deputy executive director of the Funders Committee for Civic Participation. Prosecutors will need to show that there was another crime that Trump may have been trying to cover up or further, when he allegedly lied about how the Cohen payments were recorded, in order to make it a felony. The details of the underlying crime are only hinted at in the accompanying statement of facts, and the prosecutor's comments made on Tuesday, not in the actual indictment. They outline a legal plan to sway the 2016 election by preventing the public from learning negative information about Trump. Concerns about whether the case will hold up in court are being raised by the district attorney's theory, as well as the lack of transparency surrounding how Bragg intends to present it. Rick Hasen, an expert in election law, told CNN that it was far from a slam dunk. Hasen, a professor at the UCLA School of Law, stated that it raises some political questions whether this is the case to bring. It's possible that years of litigation are still to come before the case is fully settled due to its complexity. John Coffey Jr., a professor of white-collar crime at Columbia Law School, predicted that this case would ultimately end up before the U.S. Supreme Court. The former president cannot be found guilty based on a novel legal theory without the Supreme Court reviewing the case first. 3 ways to commit a crime, each with their own challenges in order to support the felony charges. Manhattan prosecutors have hinted at 3 different potential underlying crimes, each of which raises a unique set of novel legal issues. The first argument is that the company records were fabricated to hide the federal campaign finance crimes committed in 2016, with the hush money payments to women, alleging extramarital affairs with Trump. Cohen admitted to these crimes in 2018, and as a result, his sentence was reduced. Hasen stated that he was skeptical that charges brought in a state court could be supported by a federal campaign finance investigation. The New York false record statute appears to contemplate the commission or concealment of any crime, according to Bragg's defenders, so they contend that it covers violations of federal law. In either case, the issue could be debated during the pretrial stage. The second potential underlying crime is a New York misdemeanor that forbids 2 or more people from participating in an election, which Bragg mentioned in his press conference. On whether or not that state crime accusation could serve as the basis for the felony, election law experts have differing opinions. The argument centers on whether state prosecutors can pursue conduct that is connected to a federal election, in this case the 2016 presidential campaign, and whether the legal doctrine of preemption, which comes into play when a federal law appears to supersede a state law. According to Jerry H. Wolfeter, a seasoned election and campaign finance attorney at Strucken Lavin, federal election law, generally speaking, preempts state election law when it comes to governing of federal elections, except there are exceptions where certain state election laws can come into play. Evidently, prosecutors gave this enough thought to decide that they were within their rights. The charging documents also appear to imply that there was an intention to break New York tax laws, which could be used as justification for the felony. Theoretically, the Cohen reimbursements would have received a different tax treatment based on how they were set up in the Trump business records than they would have if they had been properly documented. Professor of law Ian Goodman of the New York University said to CNN's Aaron Burnett on Tuesday night, that is state tax crimes. That is a stronger case because it is shielded from a lot of the legal challenges, of which there are strong legal challenges to be made to election law crimes, the author said.